Without objection, the chair is authorized to declare a recess of the committee at any time. Today's subcommittee hearing is about the administration's decision to end consideration of requests to defer deportation, including for critically ill children. We have a number of members who are waiving on today, and we are delighted to have them. And without objection, I will waive on Katie Hill from California, Mark Desaulniers from California, Rashida Tlaib from Michigan, and Glenn Grothman from Wisconsin, all members of the broader Oversight Committee. I now will recognize myself for 5 minutes to give an opening statement. I want to welcome all of our witnesses and their families who've come from all over the country today. And I want to thank them for testifying, particularly Ms. Bueso, who is from Mr. Desaulniers' district in California, and Mr. Sanchez, who is from Ms. Presley's district in Massachusetts. It's hard to imagine what the past month has been like for you and for your families, and I appreciate your coming forward bravely to share your stories with us. I also want to extend my gratitude to Ms. Presley and Mr. Desaulniers for their characteristically excellent efforts to address this current turn of events. And I also want to thank our other witnesses, Dr. Donaher, Mr. Marino, and Mr. Homan, for coming today. We are here to discuss the Trump administration's decision to deport critically ill children and their families from our country. This policy is completely at odds with American values. People come to our country to receive life-saving treatment from our pioneering doctors and hospitals and researchers, and we do not expect our government to implement life-denying policies. Last month, without notifying Congress or the public, the U.S. Citizenship and Immigration Services, USCIS, began denying all non-military deferred action requests. Most of these requests are made by sick immigrants and their families who are seeking to stay in the United States to receive critical medical care that is simply not available to them in their home countries. The administration decided to cast out some of the most vulnerable and defenseless people on earth, and there are families across America whose children would essentially be sentenced to death eventually by this stunningly harsh and cruel policy. Ms. Bueso, who's here today, was invited to the U.S. to participate in a medical study on her disease that extended her life expectancy by 10 years. To live, she relies on a weekly infusion that's unavailable in her home country, and she'll tell you about it. Mr. Sanchez, Jonathan, whom I've met, suffers from cystic fibrosis, a disease that my family knows well, and I am also the proud representative of the Cystic Fibrosis Foundation in Montgomery County, which has led a campaign that has absolutely transformed the treatment of cystic fibrosis and made America the leader in pioneering medical research and change in that disease. Jonathan's parents lost his older sister to the disease due to dramatically inferior and substandard medical care in Honduras, and he will tell you about that. And now they face the prospect of being sent back there. Joaquim Norville, a 7-year-old boy from Guyana who was in the United States when he suffered a seizure and was diagnosed with epilepsy. He was visiting his grandparents, who are U.S. citizens. Thanks to deferred action, his grandparents did not have to send him back to Guyana, where continuing treatment for his collapsed lung, colon infection, and the removal of his large intestine was essentially impossible. His mother fears that returning to Guyana now would be, quote, signing my son's death warrant. Serena Badia, a 14-year-old with a congenital heart condition, has already gone beyond the life expectancy given to her by doctors in Spain. I think actually Serena's 16. I'm not sure if I've got the right information there, but she'll correct us. An 8-year-old girl in Miami suffering from nerve cancer relies on her dad to take her to monthly treatments in New York. Her father needs deferred action to stay in the United States with his daughter. A man from Venezuela has been able to care for his wife, who suffers from a brain blood flow malformation, and his daughter has metastatic stage 4 neuroblastoma. The administration told him to leave the country this month or to face deportation. This new policy threatens sick immigrants who may be forced to leave America and end their life-saving treatment. It threatens U.S. citizens and lawful residents who rely on immigrant family members for financial and emotional support while they're here. It threatens crucial medical research and progress by undermining clinical trials that rely on the participation of immigrants with rare diseases, and we'll hear about that. The officials responsible for this policy must be held accountable for their recklessness and their failure to take even the most basic steps to determine the incalculable harm that would have resulted from this policy. The administration's decision to expel these immigrants was exacerbated by the limited time they were given to leave. According to medical experts, 33 days is not nearly enough time to even attempt to arrange for proper continuity of medical care overseas. For days, USCIS and ICE squabbled about who was responsible for the decision and how to implement it, and whether there was indeed a new process for stay requests. As they bickered, families were left in panic with all-consuming dread and terror. USCIS claimed that ICE would consider stay requests, but ICE denied those reports. The only recourse ICE offers would require vulnerable families to risk deportation before they can request a stay of removal. This is the unnecessary collateral damage facing every family caught between this bureaucratic tug-of-war between USCIS and ICE. It appears that no one in either agency contemplated or cared about the full implications of this change for the families involved. This administration's recent so-called reversal of the policy does not resolve the life and death consequences faced by many more families. After these heart-wrenching realities became public, the administration backtracked and announced that it would reopen all deferral requests that were pending on August 7. But there are still critical questions left unanswered. Will anyone who applied after August 7th be eligible for relief? Does the administration actually plan to grant relief to those who have reopened applications? What will happen to families that are currently receiving deferred action but will need to reapply once their 2-year stay expires? Without answers to these key questions, the administration's reversal appears primarily aimed at avoiding a tidal wave of criticism from the public. It gives the appearance of change without necessarily altering the essence of the policy. The administration must immediately and completely reverse this policy and continue granting deferred action requests in cases of the people who are here today and those like them. There are people who applied after August 7th who are still facing the 33-day deadline to leave America, a deadline that will arrive within days or weeks for some people. That's unacceptable. There is no justification for the incompetence of this decision, and there is no excuse for the recklessness displayed by our government in this whole affair. I look forward to having a serious and rigorous analysis of these events and a discussion of how we can all move forward together to repair the damage. It's now my honor to recognize our distinguished ranking member, Mr. Roy from Texas, for his opening statement.